This video does not define or outline the Section 106 process. It aims to advise applicants and agencies on best practices and practical ways to streamline the process to prevent delays, confusion, and negative impacts to cultural resources. Resources, including free online training, videos, and webinars, are available to help applicants seeking federal assistance for an undertaking to understand the basics of Section 106 and learn about their role and responsibilities in the process. The Advisory Council on Historic Preservation hosts a series of free webinars that cover multiple aspects of the Section 106 process. These are useful for both applicants and new agency personnel who are unfamiliar or inexperienced with Section 106. Several other government agencies also offer online resources. Completing the online learning is a great first step. If applicants have additional questions about the Section 106 process, they should contact their project manager at the lead federal agency. The federal agency leads the Section 106 process, but agency professionals and applicants should understand what cultural sites may be impacted by the undertaking and who the other interested parties are. At the federal agency's guidance, work with the Qualified Cultural Resources Management, or CRM professional, to research potentially impacted historic properties and cultural landscapes in the area of potential effect. Organizations without a qualified CRM professional on staff can contract one. In Iowa, anyone can access iSites Public to learn if previously recorded archaeological sites and historic structures are present in a 1 square mile area. Information on the exact location of archaeological sites is confidential, but a qualified CRM professional can conduct, at the lead agency's guidance, the proper research to understand what is currently known about the area of potential effect and what sites may be impacted by the undertaking. New sites might be identified during archival and field research. Do not put the burden of education on the interested tribal parties. Take time to research the tribe's official websites and inform them about details on the affected historic properties. Learning about their history, the impacts of Indian removal, and how their cultural or heritage preservation departments work will increase understanding and efficiency in the consultation process.
There's a lot that can be learned about specific tribes. And what I advise people to do is to go to that tribe's website. For example, the Meskwaki have a very extensive website that has a lot of cultural information about the tribe and its history. So there's really no real excuse for somebody to say that they don't really know. When they identify a particular tribe, they need to sit down and learn about that as quickly as they can.
And whenever I get to talk to people, I tell them, before you ask me, which is why they're talking to me, is they want me to say, yes, go ahead with your project.
Right.
It is good. We have no problem with your project. That's what they want.
They want thumbs up.
That's what they ultimately want, is me to say, yes, go ahead. Dig your ditch and
It's fine.
it's fine. When I get to talk to people, either on the phone, I ask them, before you ask me, what do you know? What do you know about this site? You tell me. Then I'll tell you if you're right. I could tell you more. But what do you know? Have you done your homework? You're supposed, before you talk to me, you were supposed to have done your homework. You just can't call up and say, we have this project. We need you to say yes or no right away. Now. I always ask them, do your homework. You should have done your homework first to know a little bit of what's what's in front of you or what's beyond you.
Beginning tribal consultations as early as possible is critical to successful, timely completion of the process. Early consultations will alert the parties to any constraints or other risks in the planning, while allowing more flexibility for adapting the proposed project to accommodate necessary alterations.
We do our best to not delay past 30 days, but sometimes it's going to happen. And if that whole project is held up because you waited till the last thing, then you've got a problem, which you wouldn't have had if you had sent it way before, so that if I don't get back to you in 30 days, you still got time.
We meet early on because that's what it says in the regulations, that early and effective communication with tribes is what proper Section 106 needs to be done with. And that we find that often isn't the case.
TIPOs and SHPOs should be provided with good, detailed maps and other documents related to the project as soon as they are available. Always provide TIPOs with the same information as SHPOs. Delays result when this does not happen. Participants should be aware that Section 106 implementation can be time-consuming. The more detailed and complete the information provided is, the faster the process of evaluating it and completing the process will be. The process can take longer than 30 days if it is determined that there are effects to cultural resources.
I would love for agencies, federal agencies, to send me the same information that they send the SHPO, and they don't usually. The first thing that needs to be improved in many cases is the kind and quality of information that they are providing to us as tribal historic preservation officers. Some agencies are very good at providing a description of the project, and I don't need all the engineering details, but I need to know what the project is and what they intend to do with it, and in what way is it going to disturb the ground, because that's generally the primary concern, is ground disturbance. I need maps that I can read and figure out where this project is. I need to know what they have found out in terms of what archaeology has already been done at the site, what has been found, and they can share that with me as tribal historic preservation officer. They can't share it with other consulting parties who are not tribes, but they can share it with us, and they need to be sharing that information with us up front. Because once I have that information, then I can know what needs to happen next. But if I spend half an hour trying to figure out where this project is, that's a waste of my time when it would have been so simple for them to provide the information up front.
Section 106 is a legal process. Maintain documentation of all communications, project details, and submissions records. Keep copies of everything. Don't rely on the other parties to keep copies of anything. You need to be able to reconstruct the events of what you did during the process, when you did it, and who you submitted it to. Missing information causes unnecessary delays. Applicants should contact their lead federal agency before they contact a SHPO or TIPOs. Contacting these parties before they may have received information from the agency is adding an unnecessary step. When the SHPO and TIPOs have to redirect inquiries, it takes up staff time and delays the process. Consulting parties should keep everyone in the process up to date at all times. Getting all parties on the phone or in the room at the same time will save time. Applicants need to be diligent to stay informed during the process. They should not count on someone else to reach out to them. Work should not commence until Section 106 has been concluded and the project has been approved by the federal agency. Likewise, the applicant needs to comply with all conditions and keep all consulting parties apprised of any proposed changes to the scope of work. There are 4 sequential steps in the Section 106 process, but if there are changes to the scope of work or other project aspects, the process may have to go back to Step 1. In summary, these are just some recommendations for Section 106 best practices. Do your due diligence to ensure an efficient process.